This is Michael Popok, Legal AF After Dark. We just had an amazing episode of Legal AF, the leading podcast at the intersection of law, politics, and justice. We do it one place, exclusively on the MeidasTouch network. And this past Wednesday, my co-anchor, Karen Friedman, Agnifilo, and I got all caught up in, and therefore caught you up in, what's going on with the New York civil fraud case in which Donald Trump, his businesses, stand over a crevice about to disappear into oblivion if the New York Attorney General has their way. This was the wrap-up, week 11 of the trial. So much happened that we had to cover it in an extended clip, and here you go. Take a listen. And into 2024, and then trials. 2020, the year of crimes. 2021 and 22, the year of investigations and indictments. 2023 and a half appeals, and 2024-ish trials. And that's just what we're going to do. Continue to follow the life cycle of all these cases involving Donald Trump and others that followed him. Speaking of Donald Trump and losing everything, the New York civil fraud case has finally reached its conclusion 11 weeks in. There was no Donald Trump testifying in his own defense. There was no Eric Trump testifying in their defense. There were 4 experts, none of them that were very convincing, except one got into a shouting match with the New York Attorney General, in which a lot of "how dare you" and "unhand me, sir," and whatever else was going on there was going on, because he didn't like the fact that he was called a paid, what's the word I'm looking for? It starts with a W and ends with an E. You guys can figure it out. But that's what that was basically implied, that he took $900,000 to say anything about things that he knew nothing about, which was whether banks actually rely on statements of financial conditions in making lending decisions. That's been the problem with the experts that have been so-called experts that have been presented by Donald Trump. They don't go to the heart of any of the issues that the judge has to decide. You know, how you buy insurance, right? That's not the issue. You know, if you don't know how Deutsche Bank relied or didn't rely on the statements of financial conditions, then get out of here. Go. You know, if you don't know those fundamental fact questions, or you've based your expert opinion on things that are outside the record or are not consistent with the record, you are going to be shot down. It's a waste of time. And as I tell people about jury science in teaching my lawyers about trial practice, jury science tells us that juries make the decision about who wins and who loses in the first week of the trial. Doesn't matter how long the trial is. Could be a 12-week trial. First week, they are ready. Now, they'll continue to test their theories as the trial progresses, but they have a knee-jerk gut reaction early on about the case. And now this is even more acute when it's just a judge making the decision. And so if juries are just waiting for the lawyers to shut their pie holes so they can make their decision, what do you think the judge is doing? And you saw the frustration of the New York Attorney General. And at one point, Mr. Wallace said out loud, as they were wrapping up some logistics, and Chris Kice, the lawyer for Donald Trump, who's gone off the rails in this case, really in an embarrassing fashion. As a fellow Florida bar member, I will say that. Chris Kice said, Judge, now that we rest and we want to move for directed judgment, we win. We win. You don't even have to make a decision. We win. And we want to file a motion about winning. And Mr. Wallace said, what's going on here? The New York Attorney General already won the persistent fraud count, the first count of the petition of the complaint. We're just here trying to figure out whether there's more fraud and more counts of fraud. You know, so another pointless PowerPoint presentation masquerading as a motion for directed judgment coming. What a waste of time. And Judge Engoron already said, Chris, you can make it, but I'm going to deny it. Not because he's not giving it reflective thought. He's thought about it now for weeks. It's because it has no merit. It's the 5th time that Donald Trump and his lawyers have jumped up and down and called for directed verdict or directed judgment. Michael Cohen testified. Oh, Michael Cohen. Oh, directed judgment. You know, another thing. Oh, stop. You're not getting directed judgment. You're going to wait for the judge next month after oral argument to the final presentation, a closing argument, to make his ruling. And if you don't like it, go take it up with the First Department Appellate Division. And if you don't like that, go take it up with the New York Court of Appeals. And that's what's going to happen. And they're going to be on the losing side. And this is one of the reasons Donald Trump didn't show up. What did you think about sort of the last, we'll do it briefly, your takeaway from that, and what do you think Engoron does next month in this civil fraud case about Donald Trump's empire and his ability to hold on to it?
Yeah, look, this case, they kind of flamed out at the end. The defense, they didn't call their star witnesses, the Trumps, but I do think they actually made a little bit of hay with the remaining counts. They put on the 2 Deutsche Bank people who said, "Hey, we didn't rely on it. We did our own." It was not material essentially, and we didn't rely on these documents. And you don't need that materiality or intentionality or reliance for the count that Judge Engoron has already found them liable for, the persistent fraud count. But the other ones, actually, the remaining ones require some kind of intentionality or materiality, and also have that added element that they committed certain crimes, right? It's civil, but it's, it was crimes that Alvin Bragg got a lot of flack for not charging. But I have to say, when they testified and you heard what the Deutsche Bank people said about how, we did our own analysis and we would have loaned him money anyway, we were looking for the whale or whatever, they said, I started to really think about Alvin Bragg's case and why he didn't bring that case. It makes a lot of sense now because there's going to be, they're struggling with proving that those remaining counts for a lesser standard. And so to have to prove that beyond a reasonable doubt when you've got people from the bank basically saying what they said, I do think that makes a lot more sense now why Alvin Bragg was reticent and hesitant in bringing that case. And again, he got a lot of flack for that because of the loud resignation of the prosecutors who did think the case should be brought. And so a lot of people gave him a hard time about that. But I thought that the defense case really showed that there are some questions about it. I also think that Judge Engoron is going to potentially, and I've said this before, and you've said this before, he's going to potentially, split the baby, if you will, and not necessarily give the Attorney General the rest of the counts, maybe give them some and say some for Trump, so that on appeal, when Trump says this is bias and no one was listening to me and he had his mind made up from the beginning, the appellate courts can say, no, it's clear he was listening because he actually found for you, and it protects the record. And I think that's what they're going to do. I also thought it was interesting. I expected that the Attorney General on rebuttal would have put other Deutsche Bank people higher up. You've done a great job at educating us, myself included, about how banks work and how the people that Trump put on aren't really the decision makers, that it's other people. And so I expected the Attorney General's office to put those other people on rebuttal, to just say, no, it does matter. And
I think they would have, not to interrupt you, I think they would have if there was a jury. I think with the judge, there's already documents in place about what underwriting did, which is the processing place for the loans and what their requirements were. And I don't think you needed, but I am about to start a trial on Tuesday. It's a different thing. I have an arbitrator. If I had a jury, I'll make different, and so will you, calculated decisions about presentation of evidence. I think they think that they have a very strong case.
They do have a strong case, but you still have to prove your case, though. Anyway, I'm just, again.
Well, I'll give you an example. Of the 6 counts that are remaining, you've got insurance fraud and the conspiracy around insurance fraud. Deutsche Bank doesn't help with that. I think I pull it across. I think they've won on that in terms of the evidence that they were able to present. On business record fraud, very similar to what Alvin Bragg is doing, and the conspiracy around business record fraud, I think they've got a problem with the records of the company related to those issues, regardless of whether Deutsche Bank relied on it or not. Pull that across. Now you're just left with statement of financial condition fraud and the conspiracy around that. And maybe that's where, as you said, he throws him a bone and says, that one I'm not so sure about, on intentional and materiality and reliance. That one I'm not so sure about. Maybe that's.
But don't forget, with business record fraud for Alvin Bragg, it's only a misdemeanor unless you were doing it to cover up another crime.
But this is civil. Right? But this is civil.
I know. But I'm just answering the Alvin Bragg.
Sure.
Look,
I'm just saying it's a business. I'm sorry. I don't mean to talk over you. Go ahead.
No, you're not. We're having a discussion, Popok. I love it.
Right. And we're in a different room and a slightly different camera angle. And so, although in the same city, I will say that. If we could figure out a way to answer a question nobody ever asks anymore. Remember that time Karen and Michael got together in one room at a
One time.
podcast table? We did it once. It was a terrible studio. We'll never do it again. But if we could find a way, Salty, to be in the same room at the same time with two mics, a la Joe Rogan or something, we would do it. I would do it. It would be a lot of fun. I won't even write what. That's rude, Salty. And I can, by the way. Okay, so Salty's going to break in a minute. Like, wait a minute, that's not what I meant. All right? Let me. I got the good old fashioned giggles there for a minute. But no, my point was that we keep talking about in shorthand six fraud counts left. Those are the fraud counts: insurance, business record, and financial statements, and the conspiracies around each of those. I think the one that, if you're right, that the judge is looking for a place to give, it's going to be on the Deutsche Bank financial statement fraud that they didn't prove the elements that are required, which is intent and materiality / reliance. That one would be good. I didn't hear anything that countered the insurance fraud. I didn't hear anything from experts or otherwise that countered the business record fraud. And so for me, there's going to be 5 total counts at least. 4 total counts at 4 plus the 1, 5 total. 5 fraud counts total that this judge is going to find in January. And then just on the first fraud count, he could give all the relief probably that the New York Attorney General is looking for, which is, as I did in a hot take, dissolve all of the companies for Donald Trump under a monitor and receiver, liquidate the assets in order to pay whatever the disgorgement amount is, and forget the $250 million we talked about a year ago. This is $500 or more million based on the numbers that were put up on the board by the experts for the New York Attorney General about how much ill-gotten gains, how much over-borrowing they did, how much benefit they got from lying, and that's the measure. And so $500 million, liquidate assets, remove Donald Trump as a trustee for his own trust, bar and ban Donald Trump and his children and the other executives from ever being New York corporate officers or directors ever again. The Trump organization in New York could never borrow money in New York and can't transact real estate in New York. That is the dystopian apocalyptic world that Judge Engoron holds in his hands.
If that happens, will Trump,
I love saying that, by the way.
No, but I love learning these things because it's fascinating to me. So let's say that happens and Judge Engoron says $200 million and then they appeal. Will he have to park that money in the bank the way he's doing with E. Jean Carroll, right? He had to put $5.5 million in the bank while they...
Yeah, there's going to be an argument that in order to get what we call a supersedious bond to stop the enforcement of the judgment, you got to put up money unless the Attorney General agrees. They already parked certain issues. I don't know if you remember, but right around the time he issued his ruling on the first count, he was ready to dissolve. He was like, okay, let's go to dissolution of the companies and all their certificates and their ability to operate in New York. And even the Attorney General was like, let's do the trial. Why don't we do the trial first, Judge? He's like, all right, we'll do the trial. Okay, but I'm ready. That's why I think this ruling comes. So he's going to be, just to give Donald Trump's January, he's going to be in some sort of primary. At the same time, he's deciding, again, not to testify in the second E. Jean Carroll case. At the same time that the ruling in the New York Attorney General case comes out against him for hundreds of millions of dollars. And that's just January. Civil. And then all the criminal stuff. But you're right. I was laughing because you were like, yeah, I'm not used to this civil stuff. Yeah, you're just used to putting people to rot in jail for the rest of their life, which is great. I appreciate that as well. I've never had that power. I only had the power to take money.
That's why I love civil. Civil is like, I feel like it's the greatest thing. It's like you're a private prosecutor, but with a much better burden of proof. No, it's like it's the burden of proof issue is just so much.
Can you imagine as a prosecutor if you could work on commission and take a contingency fee?
Well,
that'd be great, right? For for civil forfeiture, you get 10% of whatever you bring in. That'd be like
amazing. Then the motivation there becomes a problem. It becomes problematic.
Well, if you like that particular clip, you're going to love what we do every week, twice a week, only on the MeidasTouch Network. and it's called Legal AF. It's exactly what you think. It's on Wednesday and Saturday nights at 8 p.m. Eastern Time. And then the leaders of Legal AF do hot takes. Who doesn't like a hot take? About every hour, also on the MeidasTouch network. If you know what I'm talking about, welcome back. We appreciate you being part of our audience. If you have no idea who I am or what I'm talking about, I'm Michael Popok. That was Legal AF. And join us. Take a listen. And if you already are a subscriber to the MeidasTouch network or like Legal AF a lot, take the clip we just showed, send it off to friends, family, or people in your life, and get them to join. Free subscribe to the MeidasTouch network. That helps too. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.